Deputy Willie Penrose.
I want to thank my colleague for bringing this important piece and timely piece of legislation before the House. It's important in the context of trying to secure and save jobs and try and keep business operating in a very difficult environment. It is clear from our discussions with retailers on this issue, and indeed I invited Retail Excellence Ireland in February 2009 to address our committee here on this particular issue, that exorbitant rent contracts are basically forcing retailers on our high streets out of business, and this is happening across the country, where one encounters businesses that are trading away and, whilst struggling to keep their doors open in the absence of credit from the banks, which is another major issue, suddenly find themselves closing their doors. The impact of this is that more and more jobs have been lost, and these employees and further number of employees find themselves joining a never-ending dole queue. Obviously, the practice of upward-only reviews, which at all times is anomalous, but is clearly out of sync in the current economic circumstances, in what should be a pure commercial property market, insofar as in the normal course of business, it is the supply and demand for such premises that should dictate the ultimate price. In this case, the rent charge appears to have no application in this particular commercial market, where market rents could only go one way, and that is up. It's incredible when you think about it. I acknowledge that this practice in respect of all such future leases is now banned from the 1st of March 2010. But for many well-known retail outlets across the country, the new legal provision will provide little or no solace or comfort, as these are locked into substantial upper six-figure annual rent agreements with no escape hatch. And as their turnover continues to plummet, we see the evidence of the fallout. Many well-known and established outlets, as I've said, have ceased to exist, and others are up for sale. And the casualty list of this crazy practice continues to grow. Surely these clauses are anti-competitive in nature, as their sole purpose is to insulate the landlords from commercial reality, whilst the unfortunate tenant is pummeled into submission and eventually closure due to these prohibitive rent demands. So as legislators, we cannot continue to sit upon our hands and allow the shutters to fall across our streetscape, in the full knowledge of the consequent impact that this inertia will have for employment in the retail sector. And notwithstanding the legal niceties and complexities which no doubt will be trotted out again this evening in response to this very important piece of legislation, we must pursue vigorously a solution which is grounded upon the very important constitutional principles, which reflects what is best for the common good. And where there are constitutional issues reflecting a hierarchy of rights involved, we must resort to what is in the common good and which seeks to achieve social justice, which is permitted in the Constitution under Article 43. A do-nothing stance in the current economic climate will see more of our well-known companies up sticks, and where our current business model clearly makes no sense, the spectre will arise that many of the prominent international names will follow suit. I am somewhat fortified in my thinking and argument that it is feasible to draft legislation now which would be of help to hard-pressed tenants and would pass muster from a constitutional viewpoint by a perusal of a very important article written by Professor David Gwynne Morgan entitled "Do Changes in Landlord and Tenant Legislation Apply to Pre-Existing Tenancies?" in the Conveyancing and Property Law Journal in 2009. Professor Morgan points out very succinctly that in the past 20 years or so, several laws which have modified the landlord and tenant relationship have come into operation, and many have applied to existing cases and leases. And the case of Shirley v O'Gorman, a Judge Pearce judgment in the High Court, is instructive in this regard. I know that is in the Supreme Court tomorrow on appeal. I will briefly quote from Professor Morgan's very enlightening article in this regard. He states, "Landlord and tenant law is an area which, because of its origins in the midst of feudalism in bygone centuries, has frequently been considered to be in need of radical change by legislation. Moreover, in practice, as we shall see, the attitude usually taken by the legislator, as with other such long-standing arrangements as companies or families, is to apply the new law even to those tenancies which existed before the change of law. A major policy point which would support this view is the simple one that individuals or companies have to take their chances with major, unexpected changes to the economic, business, social or personal environment. Why should they be protected from legal changes? Another practical reason for this is that tenancies tend to be long-lived, in comparison with, say, torts or crimes, or even the time taken to perform most contracts. Accordingly, if the legislator were to decree that its changes should not apply to existing tenancies, it would take a long time to come into effect. In addition, the law would be limping on several legs, with different regimes for different generations of tenancies. Need we say more? If one looks at the Landlord and Tenant Grounds Rent No. 2 Act 1978, which the Minister will be very familiar with, it came into effect in August 78. This applied to existing tenancies, albeit the landlord was entitled to some small compensation. But the tenant was entitled to a larger's interest into the acquisition of the fee simple. This might, on a strictly literal reading, be construed as an interference on the landlord's right to recover the fee simple, but it passed muster. Article 43, subsection 2, subsection 1 of the Constitution is of significant importance in this case and is of paramount importance in the construction of this piece of legislation before us. It states, the state recognises, however, that the exercise of the property rights mentioned in the foregoing provision of Article 43 ought in civil society to be regulated by the principles of social justice. Subsection 2, the state accordingly may, as occasion requires, delimit by law the exercise of the said rights with a view to exercising their exercise with the exigency of the common good. In Shirley's case, one has no doubt, but that the social justice aspect of the argument prevailed, and that a proper balance between the property rights and social justice arguments can, to paraphrase David Gwynne Morgan again, be best left to the democratically elected legislature rather than a court. So, in this case, the freehold reversal was acquired for the landlord. Judge Pearce remarked in a nobiter dicta, other factors apart from pure economic factors come into play to which a government may have regard in deciding on social policy. These can be other factors or disadvantages affecting the enjoyment of a property, which arise from the status of the tenant. Ownership is not absolute, and there still exist the remnants of obligation between landlord and tenant aside from the payment of a rent, which have led to measures being taken from time to time by the legislature, and which have effectively emasculated the effect of certain covenants, for example against assignment, subletting, making alteration on the respective user, etc., such that a landlord will not be permitted to unreasonably withhold his consent. A measure which enables a tenant to have these restrictions removed completely can be seen as pursuing a social justice objective, which is apart and distinct from any question of wealth distribution. So Professor Morgan concludes that in most cases, changes to the law, often radical changes, do apply to existing tenancies. And he instances in cases where radical pro-tenant changes were introduced in the 1931 Act and extended in the 1980 Act and indeed in later acts. He opines quite precisely. It would probably also be the case with any remedying legislation which might be enacted to alter the upwards only rent review clause. The bill is addressing the special emergency or exigency that has arisen from the application of upward-only rent reviews and the horrendous economic impact that these clauses are having for small and medium-sized enterprises, where the rent review, which generally occurs every 5 years, leads to companies closing down or winding up or whatever, with the consequent loss of jobs and business activity. So once the legislature considers that a measure is reasonable and necessary for the common good, it will not constitute an unjust attack. I know all the cases the Minister trot out, and I have a fair idea of the advice, from Blake versus Attorney General back in the early 80s, and right through, and it is clear that in each case the Supreme Court considers whether the aim or dominant objective of the legislation is for the common good, and whether what is proposed amounts to an unjust attack on property. And that's the balancing of the rights. Here, in relation to what we are discussing this evening, that having regard to the exceptional economic circumstances and the significant hardship suffered by existing tenants who are now subject to upward-only review clause and releases, and having regard to the exigency of the common good and the principles of social justice, and where the existing regime is clearly unfair insofar as it locks tenants contractually into exorbitant rent regimes and rent processes that bears no relation to market realities, then the legislation prepared by my colleague so assiduously, Deputy Kieran Lynch, and I want to compliment him again, should be accepted and, if necessary, Minister, amended or modified as you see fit, in accordance with the constitutional advice of the Attorney General or whoever. But delay is no longer an option. Foot dragging has to be replaced by action. And I exhort you on behalf of the hundreds of individuals and retailers, some who are in the gallery here tonight, who find themselves in that position, to accept this bill and help secure business and sustain current jobs and open up the opportunity for new jobs to be created. I believe that this bill would pass the test of proportionality, insofar as it does not constitute a disproportionate interference with the landowner's property rights relative to the objectives sought to be obtained. It should be pointed out that the landlord will still be entitled to the open market rent, which will be determined at the rate of review. Of course, in the context of the NAM Act 2009, the rent roll being generated from the property is highly material in the process and is a necessary element in arranging or arriving at a determination of acquisition values under Part 5 of that Act. And of course, the rent roll is important in that regard. And one wonders if that is the real obstacle to this legislation passing here.